This is a lecture for my professional responsibility course about a section of the Code of Judicial Conduct. The Code of Judicial Conduct is tested on the MPRE. It wasn't always tested, but they started 10 or 15 years ago. But even so, according to the examiners, they only asked 3 or 4 questions out of the 60 on the MPRE. That being said, keep in mind that some of the questions about the lawyers' rules, about the model rules of professional conduct for lawyers, reference the Code of Judicial Conduct. So for example, lawyers who are running for judicial office as candidates have to comply with the Code of Judicial Conduct provisions that are relevant to campaigns, even though they're not technically a judge yet, because if they haven't been elected. So the and some of the rules like 1.12 apply to former judges who go back to the practice of law. And of course, there's rules about like 7.6 about making campaign contributions to judges and so forth. So watch out for that. That being said, the Code of Judicial Conduct is very long and elaborate and could easily comprise an entire semester course on its own. And I recommend that my students kind of skim through it, but remember that the return on investment for the MPRE is not very high for the volume of material that there is to learn. In addition, I predict that 2 of your questions about judicial conduct that are on your MPRE would be ones that you could guess right anyways, either because they're redundant or reciprocal with duties on lawyers. For example, the prohibition on ex parte communications. So if you know the rule for lawyers, then judges have a similar rule, and so forth. So 2 of the 3 or 4 that you're going to have, you would have been able to guess anyways. And then the others are rather specific. And what I'm doing is a few lectures on where I go in depth into sections that are tested very frequently, and the rules are not necessarily obvious or intuitively obvious, or things that you could have guessed from common norms in our society. And one of those is 3.6, which refers to judges being affiliated with discriminatory organizations. Now, as a prelude, or just a little bit of background for my students, I need to explain that the Code of Judicial Conduct has a somewhat different structure than the model rules. And that is, it starts with canons, 4 canons of behavior or conduct that are sort of aspirational goals or overarching quality character traits that judges should have. And I've listed those 4 canons here. Within each canon, there's a dozen or a dozen and a half rules maybe that will look to my students more like model rules. And then for each of those, there will be comments. And so it's sort of layers where, imagine we have what my students have learned for the model rules for lawyers, but then those are organized or grouped under general canons or character traits or goals for judges that we have. And 3.6, all the rules that start with 3 are grouped under Canon 3. So let's move on. Canon 3 says a judge shall conduct the judge's personal and extrajudicial activities to minimize the risk of conflict within the obligations of judicial office. And so this looks like it's going to be a conflict of interest rule, but there's actually a lot of rules kind of packed into this. And I'm going to show you what is unfortunately a very cluttered list of rules that fit under Canon 3. So you see here, I have the text for Canon 3 at the top of this slide or screen. And as you can see, there are 15 rules that apply this. And I'm not going to, don't worry, I'm not going to talk about them all in this video. And I recognize that this sort of breaks all the rules for the advice that all the experts give about how to design nice PowerPoint slides, because this is very cluttered. I'm doing that on purpose in this case to show you just the volume of material there is to learn for each one of the canons in the Code of Judicial Conduct. And again, don't get overwhelmed, because there's not a lot of payoff on this for the MPRE or for my exam, except for some of the highlights. And so we're going to have extrajudicial activities in general, what happens when judges appear before governmental bodies, 3.3, testifying as a character witness, 3.5, use of non-public information. You get the idea. We're going to focus for the rest of this lecture just on 3.6, affiliation with discriminatory organizations. This is, of all of these, maybe the one from Canon 3 that's tested the most frequently on the MPRE, almost every time, actually. And so it's one that's worth studying in some detail and learning the rules and the exceptions. Okay, so Rule 3.6 is about affiliation with discriminatory organizations. And so these could be dinner clubs and country clubs and advocacy groups, sort of politically oriented or social reform groups that in some way discriminate or exclude certain people. So let's take a look at this. A of 3.6, a judge shall not hold membership in any organization that practices invidious discrimination. That's a great vocab word for you right there. Invidious discrimination on the basis of race, sex, gender, religion, national origin, ethnicity, or sexual orientation. In other words, if you are a judge, you're not allowed to be a member of any of these groups. Now, obviously, you should be thinking of an extreme group as sort of our textbook case. Can you have a judge who's a member of the Klan, the Ku Klux Klan? And the answer is no. That actually would, if it came out that a judge was a member of the Klan, a white supremacist group, that judge would be subject to discipline or removal. And if you are from one of those groups and you become a judge, you are supposed to renounce your membership or withdraw as a member of that group. You cannot hold membership in any organization that discriminates against other races, against one of the genders and or other genders, religious groups, other ethnicities or immigrants, for example, so for national origin or sexual orientation. Now, the membership rule is probably the easy one. If you get a test question on that, it should be a softball question. Can the judge be part of a group that's for men only? Sometimes they'll set up the scenario, or excludes racial minorities or immigrants or other certain religions, target certain religious groups. Now the B and C are more subtle though, and this is where the questions, the test questions, become difficult, and you're more likely, I think, to see multiple choice questions on 3.6 B and C. A judge shall not use the benefits or facilities of an organization if the judge knows or should know that the organization practices invidious discrimination on one or more of the bases identified in paragraph A. So I have some old photos here from clubs and groups. And again, if you've read some of the cases from the mid-20th century, you know that there were dining clubs, elite dining clubs and country clubs and so forth that didn't allow African Americans or didn't allow women and so forth. The bottom picture is from a secret society at one of the Ivy League schools. And you can see how diverse the group is. And so next, By the way, that means that if you're a judge, let's say, and you want to schedule an event or a meeting, you shouldn't use their facilities if you're aware of this. And so, for example, if the Klan has a headquarters or something in your town, it looks like an endorsement if the judge is giving talks and lectures at that venue. In other words, you should avoid association with the venues of these discriminatory groups. Now, what if you just attend an event? So a judge's attendance at an event in a facility of an organization that the judge is not permitted to join is not a violation when the judge's attendance is an isolated event that could not reasonably be perceived as an endorsement of the organization's practices. And so let's say you have a relative who is a member of one of these groups, of some group, and they're I don't know, doing a play or giving a performance or giving a talk or something like that, or you have been invited by some social reform group as a judge to attend an event that happens to be held at the hall, the meeting place of one of these groups, you can attend. And by the way, this type of exception is tested on the MPRE, so make sure it's clear in your mind, isolated incident where you're attending an event, but only if it couldn't reasonably be perceived as an endorsement of the organization's discriminatory practices. And so if as a condition of attending the event, you have to somehow affirm the agreement with the organization's vision and practices, then that would violate the rule still. Okay, let's move on to the comments for this rule. Again, for my students, while I've been doing these recorded lectures, I've adopted the practice of putting the comments in a different colored background to help you keep straight as you're watching this, that we're not talking about the rule now, we're talking about the comments. So, a judge's public manifestation of approval of invidious discrimination on any basis gives rise to the appearance of impropriety. And I put that in bold print because we're not just worried about what the judge actually thinks, or whether the judge hurt anyone. That's not the question. We're not applying some sort of cost-benefit analysis or harm principle or something like that here. It's even the appearance of impropriety is enough to constitute a violation, and why we have the rule. And because the appearance of impropriety diminishes public confidence in the integrity and impartiality of the judiciary. And a judge's membership in an organization that practices invidious discrimination creates the perception that the judge's impartiality is impaired. And then comment 2 has a definition. What are we talking about when we say discriminate? And the answer is, an organization is generally said to discriminate invidiously if it arbitrarily excludes from membership on the basis of race, sex, gender, religion, national origin, ethnicity, or sexual orientation, persons who would otherwise be eligible for admission. Now, whether they do admit here on the slide, I put this at the bottom of the slide, it's by the comment, whether an organization practices invidious discrimination is a complex question to which judges should be attentive. In other words, there's plenty of kind of unclear cases. There are the obvious cases where they simply say, you know, no people from such and such race or no such and such religion wanted or allowed. But sometimes they don't actually announce or disclose that they discriminate, but they do in practice. 3, when a judge learns that an organization to which the judge belongs engages in invidious discrimination, the judge must resign immediately from the organization. So it's possible, for example, that a judge has joined a group. Judges get invited to join lots of social reform and legal reform groups, or groups that purport to be advocating for, let's say, civil rights and civil liberties and the betterment of society and stuff like that. And these groups want judges to join because it adds legitimacy to the group to trot out the prestigious people like judges who are members of your group. And judges get a lot of these requests, and sometimes they're unfamiliar with all the people involved or what the group actually does. It sounded nice in its come-on letter, and the judge said, sure, why not? And then the judge later on realizes that this group doesn't allow immigrants or doesn't allow women or something like that. And then so the judge has to resign immediately. So this is sort of recognizing the fact that sometimes judges are not going to even be aware of the discriminatory practices of a group, and they should resign once they are. Okay, here's a pretty important exception. This does not apply to religious organizations as the exercise of the freedom of religion. And so that is not a violation of this rule, and the rule does not apply to national or state military service. And so I want to explain this part to my students just for a moment, because people are from a variety of backgrounds. And so as you may be aware, a number of religious denominations and faiths have rules, especially about women in leadership roles. And so within Christianity, within other religions, different denominations have different approaches to men in what leadership roles or clerical roles women can hold. And so in some, for example, in some Christian denominations, only men can be ordained as members of the clergy, as priests or ministers. Other denominations do ordain women and allow women to pastor churches or to be bishops and things like that. There's a lot of variety within the main faith traditions, but generally each sect or group within a faith tradition may have certain rules about this. And similarly, a lot of religious traditions have lifestyle norms, traditional lifestyle norms that would exclude people for their sexual lifestyle and things like that, depending on how conservative or strict the group is and what group it is. And so we're not going to make judges renounce their membership in a church that they're part of, or a religious denomination or sect that they believe in that's part of their personal faith. And so we have an exception for that, because obviously this would create significant constitutional issues if we didn't allow judges to have any type of faith or to be part of a faith tradition. And then the military rule is now a little bit outdated, but this is from the old days when the military discriminated, excluded gays, and for a long time didn't admit women or didn't allow women in certain roles within the military and things like that. And so when I was growing up, there was a lot of controversy about this, about, for example, college campuses had to allow the military, or were supposed to allow the military to recruit on campus, but simultaneously we're not supposed to allow groups to recruit on campus that practice discrimination. So the question is, could a judge be, say, in the military reserves, the weekend reserves, even if the military has a position that's considered discriminatory? Again, the military has liberalized significantly in the last 10 years in this area, 10 or 15 years. But at the time the rule was made, this was still a hot issue. I wanted to highlight for my students, this is from the ABA journal from 3 days before I'm recording this video. I'm recording the video on April 20th, 2020. And so this is a news item from the ABA about a judge who was sanctioned for, in Texas, in San Antonio. This was a recently elected judge who hung a rainbow flag in her courtroom, and also would send emails after trials to the winning lawyers congratulating them on their win. And so now the second part isn't necessarily under the topic of Rule 3.6, but will violate a number of other, could violate a number of other rules about the judge not doing anything to give the appearance of partiality. And that would apply even after the case of really singling out the winning side and congratulating them on their win. It makes it sound like the judge is happy about which side won. And the rainbow flag was seen as a political statement that could make some parties, for example, parties who, a church group that doesn't support gay marriage or something like that, feel like the judge is not going to treat them impartially. Even, and maybe not in a constitutional challenge about that, but to put it in perspective, if you were part of a group that's outspoken for traditional marriage values and you had something as simple as a contract dispute or a traffic accident claim or something like that, you might be worried that if you had to appear before a judge who's kind of using the courtroom to make a statement about taking a particular side in something that's a disputed issue in our society to this day. And so there was no move against the judge for having personal beliefs or expressing the personal beliefs and things like that, but the rainbow flag in the courtroom was seen as basically a political statement that the judge endorsed certain people or might treat certain parties better than others. In other words, this is a sort of counterintuitive application of the rule, but I wanted to highlight for my students that this is a lively area and a timely topic for judicial discipline and judicial sanctioning. And that concludes our lecture on 3.6.